or gas.
Please be seated. Good morning and welcome to the last day of our oral argument term. Today is November 21st, 2024. We're hearing three cases today. Justice Owens is recused, so we are joined by Justice Pro Tem Vanderwood. Thank you for assisting us today. And Justice Whitener is appearing on the screen to my right, counsel to your left as you're arguing. You may hear her ask you questions. The first case is the Housing Authority of the County of King, respondent versus Andre Knight, petitioner. Opening is Edmund Witter for 15 minutes, response from Christopher Reed for 20, 5 minutes reserved for rebuttal. Please proceed.
Good morning, Your Honor. Good morning, may it please the court. My name is Edmund Witter. I represent the petitioner Andre Knight in this action. The issue in this case before this court this morning is whether the Federal CARES Act, which requires a lessor or a landlord of a federally subsidized or federally backed property to provide a 30-day notice, whether that notice to vacate requirement pertains to every eviction action or every type of cause of action that a landlord might bring, or just non-payment.
Can I ask you I'm sorry, did I?
Well, I did just want to clarify whether mootness is at issue in this case. Do we need to decide whether to resolve this based upon a mootness question, or has that been waived, or?
Our position at this point, this is a fairly important public interest at this point that I think both parties, and I won't speak for counsel, I think would agree that a resolution to this issue would be helpful given the split between the Court of Appeals.
Thank you.
This is actually a follow-up on that. Is the CARES Act and this notice requirement still in effect? Your briefing says that this is an important question to resolve because it can come up again, but the emergency's over. It has been declared over, so will it come up again?
It will come up again, Your Honor. What is currently, there was no sunset provision within the CARES Act. If you look at other parts or neighboring provisions of the CARES Act, there was a foreclosure moratorium, for example. There was a sunset provision in that one. As far as I know, no court in the country who has reviewed the CARES Act has found that there was a sunset provision or that this provision, subsection C, isn't still in effect.
Thank you.
What we're asking the court to do is ultimately reverse the lower court and adopt the reading in Ascentista, which was based off the plain language in the statute. Now, subsection C1, as I think this court's aware, when reading a statute, the objective is to discern the Congress's or the legislative body's intent. And the quickest way to do that is by just looking at the plain language in the statute. The section that we're talking about is subsection C1 of the relevant statute, and it is pretty straightforward. It says that a lessor of a covered dwelling unit may not demand that the tenant vacate without giving a notice to vacate that is 30 days in sum. Within that specific subsection, there's nothing that would indicate to the reader that that is only limited to non-payment notices to vacate. There's no mention of non-payment. It's very broad. As the U.S. Supreme Court said recently in Bostock versus Clayton, when Congress uses a broad term without any exceptions, we apply the broad term. So just in that specific subsection alone, when just reading it, Congress indicated that any time a lessor of a covered property after the moratorium that ended in July of 2020, if a lessor of a covered property is demanding a tenant to vacate, regardless of the reason, they must give at least 30 days notice.
Well, counsel, if subsection 1 of C is not related to subsection 1 of B, it seems to me that the moratorium would only apply to non-payment of rent, eviction for non-payment of rent. It would not apply to any other reason for eviction. So there was no moratorium on, say, evicting for criminal conduct, for example. You agree with that?
Well, if I could break it down. So subsection B has a 120-day moratorium on non-payment filings. So during that subsection, a landlord during that 120-day period from July of 2020 is not allowed to commence or make filings for non-payment. It's pretty straightforward. Subsection C does refer back to subsection B, but it just incorporates that moratorium time period, saying, lessor, do not give that notice to vacate that's described in C1. Don't give that until after that moratorium in B.
But there's no moratorium for anything other than non-payment of rent evictions.
Under subsection B, there's no for filings. But in subsection C, we're talking about notices to vacate, those pre-eviction notices. That's a very different thing from the commencement or availing of the court's jurisdiction that's described in B.
Well, why would you give notice if you hadn't filed something?
Why would you give notice if you haven't filed? Well, you have to give a notice before you start an action. And that's pretty standard across the country, as we indicated in our briefing. Almost every state in their unlawful detainer laws requires a pre-eviction notice be served, and only after that may an actual filing or commencement of the suit in court actually begin. And just importantly, Congress does know this. Congress has, in other statutes and other housing programs, prescribed specific types of notices. For example, in public housing, they prescribe a specific notice for non-payment, another one for serious breach. For home investment partnership grants, that's a huge block grant that Congress gives to the states. They require a 30-day notice like here with some exceptions. Congress is pretty familiar with this area of law. They've often, with federal housing programs, prescribed a specific notice that has to precede that actual commencement of the case in court. Did I answer your question?
Well, maybe.
I think the way I would pair it up here is that during that moratorium, there was a moratorium on ongoing eviction filings for non-payment. But a landlord was not allowed under subsection C to also issue a notice to vacate during that moratorium either. And the way this would work is...
But I guess what I'm still confused about is if a landlord wanted to evict under subsection 1 for something other than non-payment of rent, there would be no limitation on when that could happen.
You mean under subsection C1?
Right.
If,
Because it doesn't incorporate, by your argument, it doesn't incorporate the moratorium language in subsection 1 for non-payment of rent.
right, well, under subsection C2 it does. I guess I'm having trouble following. Because what C does is, it says, number one, a landlord must give a 30-day notice to vacate with no specification of what ground. And under subsection C2, it says that notice cannot be delivered until after the moratorium in subsection B is over with.
But the moratorium only applies to non-payment of rent.
Right, but subsection C is referring generally to notices to vacate. Let me just give you an example of what could have happened during that moratorium. Let's say a tenant falls behind on the rent and has a non-payment case. Under subsection B, that landlord could not demand or could not evict that tenant for non-payment. Subsection C, though, prevents the landlord from going around and saying, hey, tenant, I know I can't evict you for non-payment, but I'm going to give you a notice to vacate because, say, you're month to month, and I'm going to just terminate your lease. In that example, basically the landlord is getting around the moratorium in B by using a pretextual eviction, by saying, I can't evict you for non-payment under B, but I'm going to demand you vacate for another alternative reason.
But during the moratorium, could the landlord have given notice to vacate for criminal conduct?
I don't believe so, based off of what we see as the plain language in the statutes. So while I understand that that may feel far-fetched, I do want to just kind of zone in on where Congress was in March of 2020. This was the beginning of the global pandemic. And so that Congress tries to make sure that tenants are staying put while this massive global pandemic and emergency is happening.
Well, let me stop you for a second. You said the plain language says that. I've just heard your discussion with Justice Madsen that the moratorium has to do with non-payment of rent.
Mhm.
It doesn't say for other reasons. And Section C has to do with the 30-day notice, which, if there's a non-payment issue, can't be issued until after the moratorium has passed. But it doesn't say for other issues it has to wait for the moratorium to have passed, does it?
Well, I agree, but it just says a landlord cannot demand a tenant to vacate.
Sure. So if somebody is accused of other violations, where does it say that you can't submit at least a 30-day notice?
In subsection C1, and then C2, actually. C2, where it says you cannot issue it until after the moratorium. So a lessor is not supposed to demand a tenant to vacate. It doesn't specify the
But the
reason.
moratorium doesn't apply, does it? It doesn't apply if the allegation isn't a payment issue.
Well, when we look at subsection C, as the court in Asantista noted, it just refers to any demand by a lessor for the tenant to vacate. There was no specification, well, there's an exception here if the lessor is accusing the person of criminal behavior. There's nothing in here that would suggest to a reader if a lessor can carve out an exception to that bar in C2 just because there's criminal behavior or anything else. Congress made a very broad rule here that barred a notice to vacate for that 120-day period, then after which requires a 30-day notice.
Can I ask, as a further follow-up to that, so under that view, does it have the effect of putting a moratorium on evictions for any reason?
For notices to vacate during the 120-day period, if you look back on it, yes. What it would not have, yeah.
But after, maybe, you talk about C2, so after the expiration of the period, you're saying the notice provision is freestanding, independent of the moratorium.
Correct.
So that, you would agree that your reading would have the effect of broadening the moratorium?
That's described in B?
That's described in B. It says
Yeah.
non-payment of rent, but you can't evict without a notice, so
Right, but what,
broadens the moratorium.
well, there would be some types of evictions that could have happened. So let's say somebody had issued a notice to vacate prior to the moratorium for behavior-related reasons. During that 120-day period, there was nothing in this statute that would have prevented a landlord from filing a case at that point. Because B says you can't file papers, you cannot avail yourself of jurisdiction.
Right, but
B.
you can't really know what your rights are as a landlord under B unless you also read C, based on your reading, because you actually can't do it, you can't issue a notice for any reason under your reading.
Yeah, during the moratorium,
So what B
yeah.
says you can't do isn't complete.
Right,
When
because
is
C,
it complete?
right, if I think I'm following. So B, like I said, B says if there's a non-payment of case that's in the middle, like you've issued a notice, let's say you issued it before the moratorium went into effect in February of 2020, you can't then go file the case. If a landlord had...
That's not all you can't do. I guess that's what I'm saying.
Yeah,
You want
yeah.
to read C1 a little bit separated from the moratorium in B, but the moratorium in B doesn't tell us everything under your reading of C. You have to, what you can't do requires you to look at C as well, because notice is necessary to start
Yeah.
the eviction.
Well, right, I think we have to read, we have to read it all together. But I'm trying to, again, the words here, again, under C1 are just so broad. There's nothing that says notice to vacate for non-payment.
Well, let me ask you more directly.
Yeah.
Here's what's slowing me down, Mr. Witter, is if it's that clear and obvious, why wouldn't you just say that in B1? Why give them a specification limited to non-payment of rent if really the whole provision means you can't do it for anything?
I don't know why Congress writes it the way they do, but I don't think that's really exactly an issue we have to, there might have been a lot of preferred ways to have done this, but the fact is this is what we have to work with. And what we have to, if we change what C says to ultimately say notice to vacate means notice to vacate for non-payment of rent, we are adding words there when the specific subsection itself, the text alone, gives no indication to a reader that it would only apply to non-payment of rent file or non-payment of rent notices. When it's
Counsel,
very broad. Yeah.
Do you think we should be concerned that all of the types of notices are being lumped together based on your analysis? In other words, under 5918-650, there's different forms, exigent circumstances, criminal behavior, nuisance, 3-day notice, 10-day notice for other items. You're indicating that Congress here intended that all of those circumstances, non-payment of rent, exigent circumstances, which I think is what we have in this underlying case, all should be afforded 30 days outside of this moratorium COVID analysis.
That's because that's what Congress said. And as I mentioned, Congress has legislated in this area many times. This law looks very similar to the Protecting Tenants of Foreclosure Act that Congress passed in 2010 in wake of the foreclosure crisis, and then they re-upped it again in 2018. But that requires a 90-day notice by a foreclosed or purchaser of a foreclosed home before they can evict a tenant. I want to note in that act, there's no exceptions. There's nothing that says if a tenant is committing waste on the property that the landlord gets to use a 3-day notice under state law compared to the 90-day notice. Congress wrote it very broadly, but also there's been other circumstances where Congress has done what you're describing, where, for example, in the Home Partnership Act, they say 30-day notice except for certain exigent circumstances. So Congress knows how to legislate, knows how to write these, but here they decided in the wake of the pandemic in March of 2020, broadly, let's talk about notices to vacate in general, because it's an emergency, and they ultimately, I think, whether it was wise or not, that's not really the problem, but they were legislating in the midst of a fairly once-in-a-generation emergency at that time, and so they used a very broad language. We just have nothing, there's nothing outside of C that really suggests that Congress wanted to tailor this to just non-payment of rent notices. And when C refers back to B, that moratorium, it's just incorporating the time period, but there's nothing that indicates that Congress wanted to modify or in any ways qualify or limit notice to vacate from to only refer to non-payment of rent notices.
Counsel, given that we are trying to construe this statute, and despite maybe assertions that it's pretty plain, if we find that it's ambiguous, what next? How do we look at legislative intent? And does Division 2, in their decision, provide some insight into that?
To me, I don't know if there's a really clear statutory tool that is going to actually be useful here. I know the court asked for the clear statement application, which I think is a little bit of a hard one to use here, because there's not a lot of precedent, especially with federal housing, where Congress is using its spending power to legislate. To me, the thing, and I just want to distinguish, the lower court relied on the economic security in the title, as saying that you should try to limit this to non-payment for that reason, because non-payment is related to economic. But I would say the Ascentista court is even better when it comes to economic security for the reasons I just said, or that example I gave earlier, where if a tenant fell behind on their rent, if the notice to vacate in C1 is limited to non-payment, then a landlord could just get around the economic security protections during that moratorium by just giving a notice for another pretextual reason. So the short is, this was a public health act, so potentially within that it's intended to be able to protect people during that global emergency, that this is what Congress wanted. The fact that that B ended in July of 2020, that Congress put a sort of a non-finite provision to this to make sure that it lasted longer until, well, we ever get out of the pandemic, so people have 30 days to be able to move out, whatever they're accused of. I think personally trying to give it that sort of public health and ultimately benefit there. Thank you.
Thank you. Response, please.
Chief Justice Gonzalez and the other justices of the court, good morning. May it please the court. I am Christopher Reed from Montgomery, Purdue, and Seattle. We represent King County Housing Authority, the respondent in this matter. The issue before the court today is whether Chapter 15 of the United States Code, Section 905, otherwise known as Section 4024 of the CARES Act, requires a covered landlord to serve a 30-day notice to terminate a tenancy, regardless of the basis for eviction, including cases involving extreme criminal activity, such as the one before the court today. Division 1 of the Court of Appeals held the unequivocal answer to this question is no, and that the provision at issue applies only to cases involving the non-payment of rent. We'd request this court affirm the Division 1 appeals ruling for 4 reasons. First, the plain language of the statute demonstrates that Section 9058's notice requirement applies only to evictions for non-payment of rent.
Do you agree with opposing counsel that this is a live issue?
I do, Your Honor. This is an issue of significant public importance. It's an issue that's likely to recur. The CARES Act, as interpreted.
So you think that your read is that the CARES Act is still in force?
Your Honor, I am aware of no legal authority that has found that the temporary moratorium on evictions, Section 9058, and specifically the notice provision under subsection C. I'm aware of no legal authority holding that has expired or otherwise sunset. This is an issue, and it's an interesting point, Your Honor. This issue was raised in the Arvada Court out of Colorado. There, the court found that the sunset provision applied only to the moratorium on evictions and not to the notice section. However, in that case, the landlord did argue that the notice provision was kind of an off-ramp to the moratorium, essentially that once the moratorium expired, a landlord had to provide a 30-day notice, in our belief, for pay or vacate cases only, as somewhat of an off-ramp to the moratorium. The court there rejected that position. I would like to make clear, we're not arguing for that here. We're arguing that the CARES Act in Section 4024, subsection C specifically, does not require a 30-day notice for criminal activity such as this case, and that resolving that issue resolves the issue before the court. So on the issue of mootness, I agree this issue is live, and I know there's a separate issue of the fact that this tenant has moved out. We believe that this issue is likely to recur. Our lower courts are grappling with this issue right now and in somewhat inconsistent manners given the different rulings between Division 1 and Division 2. So first, we believe the plain language supports our interpretation. Second, we believe such interpretation is supported by the fact that Congress passed Section 4024 to address economic insecurity, not broad eviction reform during the COVID-19 pandemic. Third, to the extent ambiguity remains, we believe the clear statement rule supports a narrow interpretation of Congress's notice requirement. And finally, we believe public policy is actually supported by applying the notice requirement narrowly to pay or vacate cases only and not to criminal activity cases.
Can I ask you a quick question about the clear statement rule? You say if there's an ambiguity, we should turn to that rule. Do you believe it applies only in instances of ambiguity, or is it part of an intent analysis or a purpose analysis regardless of ambiguity?
I don't think we reach the clear statement rule unless there's an ambiguity.
Okay.
So the ambiguity of what? Because ambiguity can exist on different levels, right? So it might not be ambiguous that the Congress intended to impose a 30-day notice requirement. That's, 30 days is 30 days, that's pretty clear. But are we looking to whether or not it's ambiguous as to whether Congress intended to disturb the balance between the state and the federal government in terms of broadly legislating in the area of landlord-tenant? So is there more than one kind of ambiguity, and what, if you think there is, what are we really looking for in the clear statement of federalism rule?
That's a good question, Your Honor. I think the ambiguity is in the statute itself. So if the statute is ambiguous, and we submit it's not, if the statute's ambiguous, we can turn to the judicial canon of interpretation, use of the clear statement rule to support a specific goal, and in this case, protecting federalism. Landlord-tenant law is an area of law that's reserved for the states. It's historically legislated by the states, and that's set forth in numerous, United States Supreme Court cases, including the Alabama Association of Realtors cases. And so I think the first question is whether the text of the statute's ambiguous, in which case, if it is, we can turn to other legislative aids, legislative intent, and potentially, where applicable, the clear statement rule. And we'd argue that applies in this case to the extent there's an ambiguity, but first, we don't think there is. And so turning back to the plain language of the statute, we think the plain meaning is that 9058 applies only to non-payment of rent cases. The title of the statute is Temporary Moratorium on Evictions. Subsection A defines to whom the statute applies, and there's no dispute in this case, it applies to the housing authority. Subsection B created a 120-day moratorium on non-payment of rent evictions. And subsection C is broken down into two subparts, C1 and C2. C1 says that a landlord cannot require a tenant vacate a unit on less than 30 days' notice. And subsection C2 provides that landlords cannot issue that notice until after the moratorium on non-payment of rent evictions, subsection B.
Well, counsel, why would Congress not have included in C the same language as B of non-payment of rent, if that was the intent?
I think that's a good question, but I think it's clear Congress intended these to be read together. And I don't think that they needed to include the same reference to non-payment of rent because they did through so C2. C2 says that landlords cannot issue this notice until after the moratorium on non-payment of rent evictions. And when we look at the text of a statute to try to discern Congress' intent, we look at the entire statute together. We read the sections together. And in fact, the petitioner's counsel just said, we read the sections together. When we look at the sections together, subsection A, it defines to whom the property applies through use of the term covered dwelling. That defined phrase comes up twice in subsection B, twice in subsection C, connecting the three sections of the statute. And in a similar manner, subsection C1 and C2, there's a connective word and. These two sections are to be read together in the conjunctive. And C2, and I think this is really important, C2 says subsection C1 creates this notice requirement, and you can't issue that notice until after the end of the moratorium in B. And so I think Congress's intent is clear. These sections are read together. There's no reason why they had to include the word non-payment of rent in C1.
As a follow-up, can I ask, if we read them together, as you both are advocating, and we read the C provision to not incorporate the limitation to the reason being non-payment of rent, then do you agree that B1 is not a complete statement of the limitation on the landlord's eviction rights?
I would agree, and I'd actually go a step further and say the interpretation that petitioner is advocating for would render B1 superfluous. As petitioner noted, we are required to serve a notice before we can file an eviction. If the goal of C1 and C2 collectively is to prohibit all notices of any kind, we don't need B. We could just say a landlord's prohibited from serving all notices during a 120-day period. In the converse, we could say there's a moratorium on all evictions for 120 days. I think those are much cleaner ways to draft the statute if Congress had intended that. I don't think they intended that. I think they intended to put a moratorium on non-payment of rent evictions, and after that moratorium ended, to provide a 30-day notice for non-payment of rent evictions only.
Counsel, I'm just have to confess, and I'm going to need your help here, because when I read C2, the reference until after the expiration of the period described, there's nothing more. So what's the period? Isn't period referencing the time when you look at moratorium in B, the 120-day period? I mean, I'm just trying to figure out how we import more than a time frame here.
Well, if I may, Your Honor, B1 specifically says during the 120-day period beginning March 27, 2020, B1 references non-payment of rent. And so we argue that C2 is directly related to the non-payment of rent. It's saying a landlord cannot issue a notice until after that period. And if Congress had intended to make that a broad eviction notice to any type of notice, criminal activity included, they could have just said, you cannot issue a notice during this 120-day period.
Could we go back to the clear statement of federalism rule? And I'd like to have you opine, if you would, about the relationship, if any, between that rule and preemption.
Okay. I'll jump ahead here. So the clear statement of federalism rule is a strong form of judicial canon of interpretation, and it provides that courts should adopt a specific interpretation if it supports an end goal. And in this case, or applied here, that end goal may be state and federal power. When Congress legislates in areas reserved for the states, it must do so in clear and unequivocal language. That's essentially what this clear statement rule says. I think Congress has noted, the court has noted that Congress must do so, must act clearly, because we have the goal of protecting federalism in the United States. The 10th Amendment confers to the states the powers not reserved for the federal government. And so I think the clear statement rule is designed to protect that. Certainly Congress has the ability to preempt state law where it desires to do so, but I think the court's made clear it must do so in an unequivocal manner to avoid overreach.
So is that the similarity then between these two canons, essentially preemption and clear statement federalism rule?
I think they work together. So I think what the United States Supreme Court has said is essentially Congress has given great responsibility and great power through the use of preemption. It's got the ultimate trump card, so to speak. And so the court's going to interpret its use of that power in the state areas in a narrow manner and doing so through a clear intent. And so when Congress legislates in an area reserved for the state, such as landlord-tenant law, it's got to do so unequivocally. Again, I think turning back to the reasons why we think Division 1 should be affirmed, we believe the plain language is clear, and so we never reach the clear statement rule, we never reach an ambiguity question, but if we were to reach that issue, we would argue that the court should adopt the narrower interpretation of what Congress intended to do under the clear statement rule, which is to hold that the 30-day notice requirement applies only to non-payment of rent evictions and not all evictions. That's the narrower interpretation.
So the Congress has set other time limits on evictions in other statutes. So if we read this statute to include all evictions, what happens to other federal statutes that have different time frames? Are those also essentially preempted or abrogated silently, I guess, maybe?
It's a good question, Your Honor, and I agree. So for example, in public housing, the standard for a notice to pay or vacate is actually 14 days. And the statutes which apply to public housing, and this is a public housing apartment at issue in this property, reference a 30-day timeline for other evictions unless the state court provides, or state law provides, a shorter notice period. And so to answer your question, had Congress intended to basically create a broad 30-day eviction notice for all types of evictions countrywide for every covered property in the United States, it would theoretically overrule all those other different shorter or longer notice periods.
That were passed by Congress. These were not just overruling state laws, but also other laws passed by Congress.
It could. And to your point, Congress here, at least, I am aware of no intent evidenced by Congress to do so. In fact, there's probably a contrary intent, especially in public housing. The court has noted previously, and this is set forth in the Rucker case, that there is a benefit in pursuing shorter notice periods for certain types of evictions. In Rucker, the issue was a 3-day notice to terminate based on criminal activity. And there, the court cited the fact that Congress has expressly found and held legislative, and basically legislative purpose, that there's a goal of providing safe, decent housing for people living in public housing. And I don't think that's served, I don't think that's furthered by a 30-day notice to evict for criminal activity. I don't think Congress intended to overrule that type of eviction notice, the 3-day eviction notice, like it did here, through an act that was passed in a matter of days in response to the COVID-19 pandemic in a bill that's very largely focused on economic insecurity and protecting people's livelihoods as they lose jobs, business disruptions occur, and tenants may not have the ability to pay rent.
Counsel, you mentioned the conflict between Division 1 and Division 2, and other than disagreeing with the result in Division 2, let me have you comment on Division 2's use of the Congressional Research Service.
It's a good question, and I think that their reliance on the CRS report was misplaced. That CRS report came out after the bill was passed, so it doesn't reflect congressional intent. It's an interpretation of the statute that was passed, similar to what this court is doing today. It's also written by 2 congressional staffers at the CRS as opposed to any member of Congress. And so it's an interpretation of the statute as passed as much as anything else. With respect to the CRS report, I know Division 2 gave that weight in their analysis. I would also caution in relying on that report. It doesn't make a conclusion. A careful reading of the CRS report says the notice provision arguably applies to all evictions, including those other than for payment of rent. It doesn't actually make that conclusion. And just because something's arguable doesn't mean it's the right interpretation. And as Division 1 noted below, no court, except for Pendleton, has reached that conclusion. Every court to consider this issue but Pendleton has said the 30-day notice requirement applies only to non-payment of rent evictions.
Counsel, you've mentioned multiple times this case is focused on criminal conduct and alleged activity. But your analysis wouldn't make any difference, would it, whether or not it was a 10-day notice under sub B or these 3-day notice under this provision?
Correct. There are a whole host of different bases for eviction under Washington law, and I'm sure other states have similar provisions. I agree it would not change the analysis whether it was a 10-day for material breach of lease or a 20-day for unwanted sexual advances. It wouldn't apply to periods of notice that are longer, obviously 60 days, 90 days, 120 days, which all exist under Washington state law, but I agree the analysis would be the same.
Though, I'm sorry, I do want to ask about the longer, because if the view is that this is, I think both sides acknowledge Congress would have a preemptive power here, and if they clearly stated, as the tenant argues, that the 30-day notice is encompassing all, why wouldn't that override other state notices or periods for eviction across the board, regardless of cause?
I think it would.
Shorter or longer?
I see, is the question then, if a 120-day notice, for example.
Right, why wouldn't the 30-day take over that as well?
Theoretically, I suppose it could, but I think that our courts at least, and they interpret the laws in favor of the tenants, and so if there's a longer notice period, I believe our courts would interpret that as providing the tenant the longer period, regardless of what Congress provided for a shorter period or not.
Under the theory that both laws still stand?
Correct.
But if both laws still stand, why don't shorter state laws still stand? I'm losing the thread between preemption and interpreting a law that might not be applicable.
I think we always interpret the law in favor of the tenant. And so if there is a longer notice period, and I think the longer notice period would apply. Now, if Congress said expressly, like it did in the public housing context, a shorter or longer notice period will apply if state law provides so. I think Congress would have to do that legislatively, and it would have to make that express. And what I'm specifically thinking of is the public housing context in which public housing leases say a 30-day notice, unless a shorter period applies. And so Congress would need to do something similar here, almost in the reverse, however. Your Honors, I know we're getting close on time, so I'd like to talk about the public policy piece a little bit, because I think we've both argued pretty well the plain language, but I truly feel that public policy is actually served through a narrower interpretation of the statute. We are facing criminal activity at a significant number of properties, and these are, at least in this case, these are families who, in many cases, are low income and don't have anywhere else to go. And we shouldn't, as Judge Dwyer noted in Division 1 of the Court of Appeals oral argument below, we shouldn't force these individuals to live in the company of tenants engaging in criminal activity for extraordinary periods of time. We think that's really important. This isn't a situation in which we're trying to penalize one tenant who's engaging in criminal activity or provide them with a loss of due process. They're going to get a court hearing. We focus on the issue more from the impact to other residents of the community, to other staff members who are working at these properties. And we think there should be a difference between a pay or vacate notice, which might be 30 days, or a criminal notice terminating tenancy, which might be 3 days. These things shouldn't be the same, in our opinion. There should be a different notice for people engaging in criminal activity than people engaging in non-payment of rent. In sum, we believe Section 9058, the plain language, clearly applies only to non-payment of rent evictions. The CARES Act, the context in which it was passed, is all economic focused. Insecurity, job loss, and tenants' inability to pay rent during COVID, not broad eviction reform. There's nothing cited by any of the parties that supports the theory that Congress intended to create a blanket 30-day notice requirement for all types of evictions. And thus, we'd request Division 1 ruling below be affirmed.
Thank you, counsel. Rebuttal, please.
I can follow up on a few points on questions that were raised. First of all, I just want to point out, contrary to what the respondent argued, subsection B under our reading would not be superfluous. And even if you just take an example of, for example, a non-payment. So if a landlord had given a non-payment notice prior to the moratorium in B, then if you didn't have subsection B, which blocked that filing or further action in the case, then technically that case could go forward during that moratorium. Similarly, if a landlord had given a notice to vacate for another reason prior to B, I know this is complicated, but the examples help illustrate that the statute makes sense. If the landlord had given a notice to vacate for criminal behavior, having a cat or an unauthorized person or a no-cause eviction notice prior to the moratorium, B would not prohibit that landlord from continuing with that action at that time.
But for the ongoing scope of the CARES Act, under your interpretation, the reason that both sides agree we should decide this moot case, that's not an applicable scenario.
Well, everything I think regarding about the moratorium, right, that wouldn't
Right.
matter at this point.
We're talking about what hasn't sunsetted. And under that interpretation, is there any scenario under which B1 has any application?
At this point, no. We're really just reading subsection C1 at this point. Even C2 is superfluous at this point. Just a few other points here. I think when you talk about the issue of how does this comply with state law, if a state law requires a longer notice, I'll just notice on the plain language of C1, it's a prohibitive statute, which this court has, when in the context of preemption, has generally found that it's a pretty reconcilable if a state law provides more protection. It just says that a lessor may not require them to vacate before the date, that is 30 days. I think if you had a state law that requires, say, 120 days, that's really reconcilable to comply with both of them at that point. Just regarding, just on the reading here, I think there's a lot of things that this court can use to be able to determine intent. Plain language is the leading one. Legislative history can be helpful. All of those things can be helpful. The problem is that we don't have a lot other than the text. What we have here is a very plainly stated C1 that says that a lessor may not demand the tenant to vacate unless they give 30 days notice.
Counsel, don't we, though, want to look at all that Congress has said on the matter of notice for eviction as part of our analysis? And so my question is, and I asked it to your opposing counsel as well, is there are many other timeframes that were set by Congress, and many of them are not 30 days. Some are much sooner. So your view would be, I guess, that those have but sub silentio been abrogated?
I agree.
But why wouldn't we read those in the context of the state's interpretation of 9058 sub C1?
We say the state's interpretation, you mean?
I mean, I'm sorry.
Okay, the housing authority,
I'm
okay.
sorry.
Yeah.
Why wouldn't we read that in conjunction, and then it would be more limited, because there are still notice provisions that are shorter.
Yeah.
And so if we read all of the things that Congress has said about notice and eviction, why wouldn't we want to give a broader, or a narrower, I guess, narrower reading to subsection C to be consistent across statutory provisions?
I agree we should. The problem is I don't know where we end up, because as counsel indicated, Congress, for example, prescribes a 14-day notice to pay or vacate. So if you adopt the reading that we do agree with at least, which is this is a 30-day notice to pay or vacate at least, then you're repealing that one. But why would you just stop there and not override the other ones that Congress has passed?
Well, I guess you'd sort of want some discussion by Congress that they intend to do that they intend to override every other reason for eviction.
Yeah, but unfortunately, I don't.
Where we have that.
Yeah, but I think the Congress, what I do think they know is that the last statute, the latest one, is going to be the one that is going to be priority. And if it is inconsistent with other ones, it's the later one that's going to apply. So at this point, this is the last time Congress has passed a statute prescribing a notice. This is all we have. And it does make sense during that global pandemic, they just did a very broad sweep. And they didn't take the time to label each federal housing statute, which are admittedly a lot, and they just decided to encompass it right here given the gravity of what was going on. So I agree we should compare it. And I also think we should compare it because it shows Congress knows how to legislate and prescribe a specific type of notice for a different type of action, and here they chose not to.
You may briefly summarize the relief you request.
We're asking that the court reverse the lower court and ultimately remand for further proceedings with the trial courts and ultimately uphold the denial of the default.
Thank you to both counsel for your argument and your briefing. The case is submitted. We're in recess for 10 minutes. Supreme Court is in recess.